let's start our lecture. So today, is everybody ready? I hope everybody is ready. Get your coffees and everything if it's morning where you are. And today we are going to, so today we are going to discuss regulation of the terms of the contract. So in the last lecture, as you recall, we discussed the terms of the contract as in what is involved in a contract, what are terms, and what are conditions, what are warranties, and things like that. So now today we are going to discuss that how courts and Parliament try to regulate the terms of the contract. Okay, so I'm going to begin our today's lecture by asking you a bunch of questions. And how about today, instead of using the chat box, you use your mic? Is that okay? And if you don't have a mic or a camera, then that's fine. You can use the chat box. You are more than welcome to use the chat box. But if you do have mic and camera, I would really like you to volunteer to speak in mic and on camera. So let's see. So today we are going to discuss exclusion or exemption clauses. Exclusion or exemption clauses is the same thing. Some books refer to these clauses as exclusion clauses and some refer to it as exemption clauses. So my first question to you is, what are exemption clauses? What do you think are exemption clauses? And I would like a volunteer who would like to volunteer to answer that question. What do you think is an exemption clause? And you can give examples. Anyone? Jennifer, could you please, if you have access to mic, could you please unmute yourself and would you like to answer this question? What are exemption clauses, in your opinion? Okay, so right. Okay, so Jennifer is saying that exempts a party or parties in the contract from certain liability. Exactly, absolutely. That is what an exemption clause is. And Yasha, you are absolutely right too. Under which one party is protected from being sued. Right. So in other words, are excluded from a liability. Okay. Good. So those are exemption clauses. So what is the purpose of having an exemption clause? Why are they there? Why do they exist? Or what do they do? So we know that under an exemption clause, one party will not be liable in certain situations. So what do they limit? They limit the party's liability, absolutely. So they either defeat or they limit the liability of the parties. Absolutely, that is the function of an exemption clause. Okay, what is a freedom of contract theory? So we are in our 11th lecture of contract law today. So I'm sure this will be easy for you to answer. What is freedom of contract theory?
I think it's the freedom of contracting parties to create any terms that they would like without government restrictions.
Excellent. Ash, very good. And let's see who else answered. Um, okay. So Jennifer is saying parties to a contract are free to agree to whatever terms in contract they wish to. Yes, absolutely. And Yesha is saying to form a contract without any restriction. Yes. So basically what Bash said, Jennifer, and Yesha said is that parties are free to choose whatever terms they want to choose in a contract. So the choice is the parties and not of the court, right? So parties can bargain with or without exemption clauses, right? So if you look at the freedom of the contract theory, do you think parties are free to choose or write or include exemption clauses in the contract? They are free to choose any term or to write or include any term in the contract. So that means that they are allowed to include an exemption clause in the contract as well, according to the freedom of contract theory. Okay, so if they are allowed, this whole theory, this philosophy allows them to include any exemption clause or exclusion clause or any term in the contract. What are the risks of having an exemption clause in a contract? So my next question is, what are the risks of having an exemption clause in a contract? Carl, absolutely. Carl is saying the risk is that the stronger party in a situation may use it to their advantage at the expense of the weaker party. So in other words, these exclusion clauses or exemption clauses can be misused. And as according to Tammy, the injured party then won't be able to sue, right? So these clauses can be misused, and actually they have a reputation of being misused. That's why we are discussing it here in our lecture today, and that's why it's part of your course, because these kinds of clauses have a reputation of being misused. And these are misused often to the detriment of the consumer. That is, you and me and general public who buy goods and services. So these kinds of clauses are usually misused to the detriment of consumers. And this is why the courts have repeatedly looked for ways to cut them down, or to, in other words, to regulate them. And but remember that courts are not against exemption clauses. They are against the misuse or abuse of exemption clauses. Okay. So these are the risks. We discussed that there are some risks related to exemption clauses, but what are the benefits of exemption clauses? A benefit could be that it might be efficient for one party to take on a certain risk for maybe a lower price, or maybe because he is insured against that risk already, right? So it makes sense sometimes it makes sense for one party to take on a certain risk. Can you give me an example of this, of having a benefit of exclusion clause? Just give me any situation where you think it would be beneficial for one party to take on a certain risk. Think of an example. Okay, so Jennifer has given us an example for example, a moving company, they might offer cheaper price, okay, but have an exclusion clause in contract limiting their liability in case of damage. So how is that beneficial to the other party? Can that be beneficial to the other party in any way? What if that moving company, Jennifer, that you mentioned, it gives you two prices, that one with insurance and one without insurance?
The benefit is that if I am moving and my property is already insured, if I have a choice between paying for a moving company that provides its own insurance and paying for a moving company that doesn't provide insurance, I can choose the one that doesn't provide insurance because I already have my own insurance, so it's cheaper for me.
Absolutely, absolutely. You answered my question. Perfect. So if, for example, Vash is already insured and have the insurance, and there are two companies. One is offering a higher price with insurance, and one is offering a lower price with an exclusion clause that they won't be liable for any kind of a damage. And she is already insured, so it makes sense for her to choose the company that offers cheaper price with exclusion clause. So that is how it can be beneficial to the other party. I'll give you another example. For example, if you're going on a vacation and the holiday package, it includes money back guarantee if you are too ill to travel. So in case you are too ill to travel, they offer you a money back guarantee, but you already have purchased an annual travel insurance. You already have your travel insurance, and that travel insurance covers that liability that the holiday company is offering you. Then, of course, you would like to pay a lower price and agree that the holiday company can exclude any responsibility it might have in the event that you get sick. So these are some of the examples where it makes sense for parties to accept or to enter into contracts with exclusion clauses, so maybe cheaper price, or maybe they are already insured. Okay. So we discussed what are exclusion clauses and why they are important and what is the risks involved. So since there are some risks involved, therefore the courts and the parliament have developed some kind of controls of those exemption clauses in a contract. Okay. So in today's lecture, we are going to discuss the common law controls. When we discuss common law controls, you have to think about freedom to contract theory that we just discussed, that parties are free to choose or to write or to make part any kind of a term into a contract. So when you think about common law controls, you also have to think about freedom of contract theory. Therefore, the courts are reluctant to invalidate the substance of exclusion clauses. So, and this rule was developed in Court of Production versus Securicore. And Court of Appeal actually tried to do this on a number of occasions, sometime in the mid-20th century, by means of fundamental breach doctrine. We are going to discuss that later on. But the House of Lords confirmed in this case that I just mentioned, Court of Production case, that the court had no common law power to strike down unreasonable exemption clauses. And if you look at the case and the time that that case was decided, you will see that there was actually this power to strike down an unreasonable exemption clause was actually no longer was no longer necessary because Parliament had stepped in and enacted Unfair Contract Terms Act in 1977, right? So that UCTA was already enacted when this case came in 1980. So there was no actually, this kind of power was not necessary for the courts at that time. And so this Unfair Contract Terms Act of 1977 is statutory basis for invalidating unreasonable exemption clauses. And then the European Union subsequently introduced a directive that required all of the member states to legislate against unfair terms in consumer contracts. And hence, another layer of legislative control was enacted, which is Unfair Terms in Consumer Contracts Regulations of 1999, UTCCR. And so this was basically enacted to comply with an EU directive, and we are going to discuss all of this in today's lecture. Okay, so as discussed, courts are reluctant to invalidate an unreasonable exemption clause. In other words, they do not want to invalidate the substance of these clauses. So they have instead developed some rules relating to incorporation. Incorporation means that is the clause a part of a contract? You can see that on the left-hand side of this diagram. Is the exclusion clause validly incorporated into the contract? In other words, is it a part of the contract? And another rule regarding interpretation. Now, this rule is also called construction, and your subject guide calls it construction, but some books call it interpretation. So both are the same thing. So construction or interpretation of clauses. This means that does the clause cover the breach? So this is another tool that they developed. So through this, they try to control the effect of exemption clauses. They cannot invalidate the substance of a clause, but they can control the effect of the exemption clauses. It is also important to keep in mind that at one stage, the courts developed a rule relating to fundamental breach or validity, to question the validity, which means that is the breach so serious that the exclusion clause cannot apply. So they developed this doctrine as well, but the potential of this approach has been severely limited by House of Lords, and you will see later on how it was, how this approach was limited. As you can see, so this area of validity is regulated by courts. Courts tried to regulate it, but House of Lords said that they had no power to declare an exemption clause invalid. But Parliament then enacted an act, and this power was provided in UCTA in 1977. All right. So first of all, in this diagram, you see incorporation as one of the tools that courts have developed. So we are going to discuss incorporation of exemption clauses into a contract. There are many ways that an exemption clause can be incorporated into a contract. But what is incorporation of a term? What does it mean? It means making a term part of a contract. Incorporation of a term means making a term part of a contract. Now, do you think this rule only applies to exemption clauses? No. Yesha and Jennifer, absolutely right. It applies to all clauses or all of the terms. it could apply to any term. Okay, so the first one of the ways that courts use this tool is through signature. So your general rule is that the clause may be included in a contractual document which has been signed by the other party. Okay, so the first case, and please excuse my pronunciation, L. Strange versus Bureau. The facts of the case are that the purchaser of a vending machine was bound by a very wide exemption clause contained in a very small print on the order form which she had signed. And the court said that when document containing contractual terms is signed, then in the absence of fraud or misrepresentation, the party signing it is bound by it. And it is wholly immaterial whether he or she has read the document or not. So that is your general rule derived from this case. So it is not of importance whether the party read that fine print or whether it was a very long document and written in a very fine print, and one of the parties didn't read the contract. So it is immaterial whether or not they read it. If they signed it, then that exclusion clause is incorporated into the contract. Now you need to keep in mind that this rule does not apply if the other party made a misrepresentation to get the signatures. So as I just mentioned that in the L. Strange case, courts said that in the absence of fraud or misrepresentation, this rule applies. And this was confirmed in the case of Curtis versus Chemical Cleaning and Dyeing. Okay, and what happened in this case was that a woman took her wedding dress to a dry cleaner's place and wanted it to be dry cleaned, and she was asked to sign something. And when she asked why she had to sign the receipt, which in fact contained a clause excluding liability for any damage howsoever caused, she was told unwittingly by the assistant that it was because the cleaning company did not accept liability for any damage to the beads or sequins on her dress. Now this was not true because, and it was a misrepresentation because the clause clearly excluded liability for all damages, for any kind of damage, howsoever caused. So the cleaning company, what happened was that they stained the wedding dress. When they went to the court, they were prevented from relying on the exemption clause to exclude its liability because they had made a misrepresentation to the woman. So no matter if one party has signed, whether or not they have signed the document, even if they have signed the document, but that signature was obtained through misrepresentation, then this rule does not apply. So what if the damage to the wedding dress was actually a damage to just the beads and sequins of the wedding dress? Then what would have been the case? What would have been the decision if the damage was to the beads and sequins? Exemption clause would apply, and contract would be valid. It would have prevented them from liability. Absolutely. Yes. Through which rule would courts would have come to this decision that you are just mentioning, that exemption clause? She signed, yes, dash, she signed an agreement of the terms. Freedom of contract, exactly. So the parties are free to choose whatever exemption clause they want to include or not. Absolutely, Sandeep, this is what I was looking for. The rule that the term was incorporated by signature. So that specific tool that the courts have developed, they would have used that tool to incorporate that exclusion clause. Absolutely. Okay. Now, another way that courts incorporate exclusion clause into a contract is through notice. So the general rule regarding this says that a reasonable for an exemption clause to be incorporated into a contract, a reasonable notice at or before the time of contracting should be given. So focus on the words at or before the time of the contract. So in Oli versus Marlborough Court Hotel, the first case on the slide, a contract was formed at the hotel reception desk when the person who was checking in signed everything at the reception desk. And so a contract was formed, offer and acceptance were exchanged, and it was formed. And the hotel owner could not rely on exemption clause that was only notified to the guest when she entered the bedroom and saw a notice on the wall. So the notice was given too late. The contract was already formed at the reception desk. It is I think it's pretty simple. And in the next case, Chapleton versus Berry, an exemption clause was written on the back of a receipt for the hire of a deck chair, and it was not incorporated into the contract. Why? Because the Court of Appeal held that that ticket or receipt was a mere receipt given out so that a deck chair user could prove that they have paid for it. And it was not reasonable to expect deck chair users to check this receipt for notification of terms, and in part because it was a very unusual practice that people would sit on the deck chairs for some time before payment was collected and a receipt given out. Now be aware that not all receipts will fail to incorporate terms into the contract. Basically, everything depends on the facts of the case and whether it is reasonable to find those terms of the contract on a receipt of that time. Okay. So, but in this case, Chapleton versus Berry, the contract was already formed. They have paid to hire that deck chair, and the exclusion clause was written on the back of a receipt. So the notice was not given on time in this case. So when you look at these types of cases, a typical issue that you need to focus on is when was that contract created, right? We just talked about exclusion clause written on the back of a receipt. Now let's talk about another scenario where that clause is written on the back of for example, a train ticket that you bought. Now, offer and acceptance takes place just seconds before you get that ticket in your hand. So remember that the courts, they do not worry about split seconds. Although the contract will be formed as soon as you exchange offer and acceptance and the ticket is handed out to you and the exclusion clause is written on the back of that train ticket, the courts are likely to incorporate that exclusion clause, saying that the notice was given to you in time. The reason behind this could be that when you're buying a ticket from a person in the booth, and as soon as you get that ticket and you read the exemption clause, and you always have a choice to return that ticket and say that, oh no, I don't want that. I need to change my seat. I need to change my reservation. So some writers think that that is the philosophy behind this rule, that you can always recall your decision to buy that ticket when you are buying it from a booth, staff booth actually. But in Thornton versus Shoe Lane Parking, the next case, an automatic ticket machine was involved. So the ticket was taken out from a machine and not from a staff booth. So I'll tell you a little bit about the facts of the case. So in order to get the defendant's multi-story car park, a driver had to drive up a ramp, pay his money, and take the ticket from a machine. So Lord Denning said that the contract was concluded at the point, and any notice of the terms on the ticket came too late. So as soon as he paid, the contract was formed, and when he received the ticket, Lord Denning thought it was too late for it to be a notice of the terms of a contract, and a contract was already concluded. So, and what is the reason why courts deferred their decision in this case? If you compare my previous example of buying a ticket from a staff booth, and this case, Thornton versus shoe lane parking. Automatic? Yes, absolutely, Penny and Sandeep. Because the ticket could not be returned immediately, it was beyond recall. And they were not able to negotiate terms. Excellent, Bash. Thornton case does not reconcile with Chapelton case. In the Chapelton case, it was decided that the document was a mere receipt, and the contract was formed before the receipt was given to them. And in Thornton case also, it was decided that as soon as the person got the ticket out of the machine, the contract was formed, and any notification of the exemption clause after that was too late. It was too late for a notice to be given at that time. But my main question card is that what is the difference between the example of the train ticket that I just gave that you get from a staff booth and Thornton's case? And as Penny, Sandeep, and Vash have said, that in Thornton's case, it is beyond recall. Another difference between Carl, between Chapelton and Thornton is that in Chapelton it was a receipt, it was not a ticket, and in Thornton's case, it was a parking ticket, and you'll know why it is. What's the difference between that in a minute. Actually, another difference that between these two cases is that Chapelton versus Berry can be an authority for the rule that the courts have developed that the documents that you receive where that exemption clause exists must be a reasonable document. It must be reasonable to find that those exclusion clauses in that document. So, so your Chapelton versus Berry is an authority to that as well. That a receipt that you receive is not a document where you are expected to find an exclusion clause. It was not reasonable for that person to find an exclusion clause on that receipt. Whereas when you get a parking ticket from a machine, it is reasonable to find an exclusion clause or the terms of the contract on that ticket. That the parking lot is not liable for any damage to your car or in case it is stolen or things like that. So it is reasonable to find that clause on a ticket, but not on a receipt. Does it make sense? Yes, Sandeep, absolutely. So the main difference actually is that the option to return is the main difference. So between the example that I gave and the Thornton's case. Okay, so as we just discussed, the document must be one on which the reasonable person would expect to find contractual terms. Okay, and so the Chapelton versus Berry can be a case for this rule as well. So, and okay, so let's think about what about in a flight magazine. You are flying to coming here to California, for example, and you are sitting in a plane and you take out the flight magazine out of the pocket of the seat in front of you, and you see exemption clauses in it and terms of a contract in it. Is it a reasonable place where you can find an exclusion clause, where you are expected to find an exclusion clause? It would not be reasonable. Jennifer, yes. No, it would not be. It could not be. It cannot be incorporated through notice into the contract, because that is not a reasonable place to find an exclusion clause. Okay, what about at the back of your airline ticket that you purchased? Or if these days there are electronic tickets, and if you have printed out your ticket and you find exclusion clauses on that ticket, it would be reasonable, yes, because you're expected. It is a place where you expect to find the terms of your contract, and they would apply. Absolutely. Okay. All right. So now you see why in Chapelton versus Berry, the exclusion clause was not incorporated. Because the receipt was not a document where you expect to find an exclusion clause. So that was one of the reasons of the decision. Okay. All right. So another thing you need to keep in mind when looking at this issue is that a higher degree of notice is required for onerous or unusual terms. So more, if a term is very unusual, the more it is unusual, the more effort you need to do to bring that term to the notice of the other party. Okay. All right. So just a summary of what we have discussed. Just look at, we have just discussed the incorporation yet. So just look at the box on the left-hand side. So control of exclusion clauses, one of the tools is incorporation, and it can be incorporated in two ways, either by signature or by notice. Okay. So all terms in a signed document are incorporated. L. Strange is your authority here, unless there is a fraud, misrepresentation, or a mistake, or non-est factum. Non-est factum is a plea that a written agreement is invalid because the defendant was mistaken about its character when signing it. And then by notice. By notice, it can be incorporated into a contract. If a reasonable notice is given. Okay, so must be before or at the time of contracting, must be in a document in which it is reasonable to expect to find the terms. It is sufficient to give a notice of where the details of the terms can be found. So you do not need to give the whole, bring the whole exclusion clause to the notice of the other party. It is adequate if it is just brought to the attention of the parties as to where to find that exclusion clause. So more explicit notice is necessary for unusual terms. All right, so let's look at another way that courts use to incorporate an exclusion clause into a contract, and that is through courts of dealing. Okay, so in Kendall and Sons versus Lilico, the plaintiff was a farmer and had bought animal feed from the defendant for 3 years, making approximately 3 purchases per month. So an exemption clause was incorporated because of regular course of dealing. Of course, they had, you can see it very clearly that they had an established course of dealing, and it was a regular course of dealing because he was buying feed from the defendant for 3 years, making approximately 3 purchases per month, and they always used to sign a document that included an exemption clause. But in another case, McCutcheon versus McBrain, the plaintiff's car was damaged during transportation on the defendant's ferry, and the plaintiff had used the ferry service on several occasions before. But the plaintiff usually signed a form which included a clause, but not always. So they used to sign that form that had that exemption clause or exclusion clause. However, on this particular occasion, he had not signed it. So the defendant sought to rely on the exemption clause due to consistent previous dealing. The issue that arose was that course of dealing consistent? They usually sign a document that had that exclusion clause, but not always. So the House of Lords found that the exemption clause was not incorporated because it was inconsistent, whether the document had been signed. So sometimes they used to sign it, sometimes they did not use to sign it. So it was inconsistent. So just keep in mind these 2 cases when you come across such an issue in an exam. Okay, now let's look at incorporation through trade practice. Your subject guide doesn't talk about this, but in other books you will see that this is another way that courts incorporate an exclusion clause into a contract. So even if there has been no signature, no reasonable notice, and no sufficient past course of dealing, it is still possible to incorporate a term on the ground that it is so common in the parties' area of business that they must have intended it to be a term of the contract. And your main case for this is British Crane Hire Corporation. And Lord Denning, in this case, thought that the objective intentions of each party were that the usual trade terms of British Crane Hire were incorporated into the contract. So he looked at the objective intentions of the parties, and he emphasized the fact that both parties operated in the same trade, and they knew the type of conditions usually incorporated in a contract for the hire of a crane. So you can say that the both parties here were in an equal bargaining position. But if one of the parties, for example, was a consumer and the other party was in that trade for a long time, that the decision would have been different. So in this case, keep in mind that both parties were in the same trade for a very long time. Jennifer is saying that your textbook discusses this concept. Okay, great, wonderful. So there's not much to read about it. I think it's quite simple, and maybe that's why it's not in the subject guide. I didn't see it, or maybe it is there. But this is the 4th way the courts incorporate an exclusion clause into a contract. Okay. All right. So we have discussed the tool called incorporation of an exclusion clause. Now we are going to discuss construction or interpretation. Okay. So construction of an exemption clause refers to the necessity for the clause to cover the breach in question. So it involves asking a question that whether this clause covers the breach in question. So there are two rules that you need to keep in mind. Contra properentum, it is if the clause is ambiguous or it is unclear, it will be construed as against the person seeking to rely upon it. Okay, and this applies to all clauses, including exemption clauses. So in this case, Newton versus Trafalgar Insurance, the plaintiff had a car accident, and the defendant sought to rely on an exemption clause to avoid paying the insurance. The plaintiff had a 5-seater car, but at the time of the accident, there were 6 people in that car traveling in that vehicle. The contract had a clause exempting the defendant from liability to pay insurance if there was an excess load. The issue that arose in the court was, could the term load be construed as covering too many passengers? So in terms of this rule, the issue was that whether that exemption clause covered that breach in question. So it was held that exemption clause did not cover a situation where the car was carrying too many people, and the word load usually does not apply to people, and therefore the defendant could not rely on that exemption clause. So it was held that the clause did not cover that that particular breach in question. So what happens in the case of excluding liability for negligence and fraud? So what is negligence? You might have read about this concept in criminal law, and you will learn about this concept in more detail in torts next year. Negligence is basically when a party is negligent when he or she breaches a duty to take reasonable care. So a claimant must therefore prove fault in the sense that the defendant did not take reasonable care, and the duty can be imposed by law, for example, law of torts of negligence, or by contract, where the parties agree to take reasonable care in performing their promises. So what happens if someone tries to exclude liability for negligence and fraud? An exemption clause intended to cover such liability must be very precisely worded in order to be effective. So keep in mind this rule that the clause has to be very precisely worded and very clear in order for it to be effective. Let's discuss this in a little bit of more detail. In the common law regime, Canada Steamship Lines is the case that gives you the guideline for this scenario when someone tries to exclude liability for negligence. So it is a 3-stage test was determined or came into being in this case with regard to clauses that covers negligence. Stage 1 is if the clause expressly exempts liability for negligence must be excluded. If it is expressed in the exclusion clause. Otherwise, if it is not expressed, the courts must proceed to stage 2. Stage 2 is the ordinary, involves asking a question, is the ordinary meaning of the words wide enough to cover negligence? And if that is the case, if it is wide enough, the courts must proceed to stage 3. And stage 3 is, could the clause cover liability other than negligence, such as strict liability? If so, the clause will not cover negligence, but will be restricted to covering the other liability, such as strict liability. And what is strict liability? Strict liability, actually, it describes a no-fault obligation. So negligence is a, as I mentioned, it's a fault obligation. Fault needs to be proved. But in strict liability, it is a no-fault obligation. For example, the obligation on the seller of the goods, for example, to provide goods which are satisfactory or of satisfactory quality, and which does not depend on whether the seller is at fault. And this liability is broken even if the reason for the defect is the fault of the manufacturer and not that of the seller of the good. The promise to provide satisfactory goods is strict and is not simply a promise to take reasonable care. So if the clause covers such liability, then it is restricted to cover only that liability and not negligence. So this is the common law test for negligence. All right. So as I said that the courts tried to develop this doctrine of fundamental breach, but there were some changes made to it. But what is this doctrine? Fundamental breach doctrine is the courts have been reluctant to allow an exemption clause to be relied upon where there has been a serious or deliberate breach of a contract. If the breach is so serious or very, very serious, and if it's a deliberate breach, then they are reluctant to rely on exclusion clauses. And since the UCTA of 1977 has been introduced, this approach has been modified, as I mentioned before. So, but you need to be aware of this doctrine and need to discuss this when an issue arises in a problem question or in an essay question. There are two categories of fundamental breach. One is where it relates to particular obligation, which is very central to the contract, and your authority for this is Parcells versus Wallace. Facts of this case is given in your subject guide, so you can refer back to your subject guide and see the facts of the case. And number two, where the consequences of the breach are exceptionally serious. So this doctrine comes into play in two cases when it relates to a particular obligation which is central to the contract, okay, or where the consequences of the breach are exceptionally serious. And the facts of this case is also can be found in your subject guide. Now let's see how this doctrine was modified. So here's a diagram for you. So see, in 1956 in Parcells versus Wallace, it introduced the rule of law. It used that approach and start of rule of law that you cannot exclude liability for breach of a fundamental term. So the Court of Appeal said that there is a rule of law that you cannot exclude liability for breach of fundamental terms. But House of Lords in Swiss Atlantic case in 1967 said that there is no such rule. Must distinguish between business and consumer contracts, and then they said that this is a job for Parliament and not that of courts. Then in 1970, Court of Appeal again used Swiss Atlantic and treated as affirming that once a contract has been terminated by breach of a fundamental term, the contract and all exclusion clauses come to an end. Again, they tried to use the fundamental breach doctrine, and they said that if a fundamental term is breached, the contract and all exclusion clauses come to an end. And then again, House of Lords in 1978 said that the contract does not come to an end on termination, only the future obligations of the parties are cancelled. And exclusion clauses remain intact and effective if sufficiently clearly worded or worded to cover that breach. The approach to fundamental breaches adopted in photo production case may be justified by the fact that there are now statutory protections for consumers in relation to very broad exclusion clauses, and that commercial contracts may appropriately be left to be governed by the principle of freedom of contract. So, as I said, UCTA then was enacted in 1977, and Section 9, subsection 1 says that reasonable exclusion clauses survive termination of contract. Reasonable, but it has to be reasonable exclusion clauses. And then in 1984, House of Lords says that still a rule of interpretation that the courts will be reluctant to find that the parties intended to exclude liability for a fundamental breach. So it started in 1956 where Court of Appeal said that it is a rule of law that you cannot exclude liability for the breach of a fundamental term, and then in 1984, and still the rule is that the courts are reluctant to find that the parties intended to exclude liability for a fundamental breach. And you will receive this PowerPoint sometime after the lecture, so that you have this diagram with you. Okay, so now let's discuss very quickly the Unfair Contract Terms Act 1977. It is pretty straightforward, but I have this diagram for you which will give you an overview of what that act is. So if you look at the left-hand side on the top, all of these sections are actually related to defining the meanings of the terms. So these are basically the boundaries of the act. So section 1, subsection 1 deals with the meaning of negligence. Section 1, subsection 2 deals with excluded contracts. For example, insurance and land contracts are excluded from this act. So it is all of these sections outside of this circle are actually the boundaries of the act as to what is a particular term, what is included, what is not included in this act. Okay. And inside of this circle, in this diagram, you see the key operative sections, okay, which is section 2, section 3, and section 6. And then you have your reasonable test that is defined in section 11, schedule and schedule 2. And the last one is anti-avoidance. So section 9 deals with exemption clause, survives termination of contract. Section 10 is evasion by secondary contract. Section 27 evasion by choice of law. This is not very relevant to your course. So the most important sections are listed on, I have listed those here on this slide for you. So please make note of these sections. You are very much likely to see those in your examination. And I encourage you to start highlighting your statute book as well, so that when you go to your exam room, you know you're already familiar with the statute book and you don't struggle with it at that time. So this act, Unfair Contract Terms Act of 1977, it applies to any clause excluding or limiting or restricting liability. And most of the key provisions of the act that you are seeing here apply to business liability. The act, this UCTA, can render an exemption clause void or subject it to a reasonable test. Now keep in mind that Schedule 1 of this act outlines contracts to which these key provisions do not apply, and that includes contracts of insurance and those relating to an interest in land. So insurance contracts and land related contracts are not included in included in this act. Okay. So I'm not going to read through this slide. You can read it at your own time. I will provide you with this PowerPoint slide very quickly. Let's look at the unfair terms in Consumer Contracts Regulation enacted in 1999. Now this UTCCR of 1999 is a set of regulations deriving from EU Unfair Consumer Contract Terms Directive, and it only applies to contracts between a seller of goods or supplier of services and a consumer. So therefore it is narrower than UCTA of 1977. However, keep in mind that it is wider in that it applies to all contract terms which are not individually negotiated and not only to exemption clauses. And I have listed the important regulations here on this slide for you. Now, So you have two legislative pieces of legislation that deal with the same area of law. So the Law Commission and Scottish Law Commission in February 2005, they produced a report and draft bill designed to consolidate, clarify, and improve this area of law. And for here's the link for you, and it will be provided to you in this PowerPoint if you want to read the details of it. Now, this paper summarized the difference between UCTA and UCCR, and it is really helpful, and it gives you an idea as to what does UCTA covers and what does UTCCR covers, what are the similarities and what are the differences. And I have put that together for you in a table form, and let me show it to you really quickly. And again, I will send that to you in an email, and you can read that on your own time, but I just want to show you how it looks like. Let me just, give me 1 minute. Okay, so while that, all right, I have it here. Okay, I'm going to share my desktop with you. So here's the table for you. Okay, so it tells you about the difference between UCTA and UTCCR. As you can see, UCTA, it applies to both consumer and business-to-business contracts and also to terms and notices, whereas UTCCR applies only to consumer contracts. And UCTA applies only to exclusion and limitation of liability clauses and indemnity clauses in consumer contracts, whereas UTCCR apply to any kind of term other than the definition of the main subject matter of the contract and price. So, and there are in total 11 differences between these two acts. And I will provide you with this document after the lecture. All right. Okay, so since there are two pieces of legislation governing the same area of law, the Law Commission made some recommendations. You just need to know this very briefly, and usually you need to mention this if you are attempting an essay question on UCTA and UTCCR in your exam. So let's look at what were the recommendations. The Law Commission recommended a simplified and unified scheme of statutory control, which would basically maintain the current controls in a single statute, more rationally and more intelligibly set out. The other recommendation they made is that consumers would continue to have a higher degree of protection than business. So this is actually, they said that this is going to continue. Consumers are going to have a higher degree of protection. But they made another important recommendation that small businesses would be given similar protections to that are given to the consumers. Keep in mind that there are two consumer protections that were not extended to small businesses in this recommendation. And these are the possibility of challenging negotiated terms and the burden of proof falling on the business. So these two protections were not extended to small businesses in this recommendation. All right, so very quickly, I'll show you how this topic appears in an exam and how you need to deal with this topic. It is pretty straightforward and very systematic, and we have not discussed UCT and UTCCR in detail, but as I said that you have these statutes available to you in your statute book, and I will provide you with the documents that I have created for you. It should be pretty straightforward for you. So if a problem question appears in your exam on this topic, first of all, you need to see if you need to ask this question: is that clause incorporated into the contract? And what are the ways that a clause, exemption clause, is incorporated into a contract? Quickly. Signing a notice, excellent. Right, so you need to consider those issues. Signature, reasonable notice, right? Convention in the area of business, excellent, Jennifer. Course of trade and course of dealing, absolutely, perfect. Okay, and then the next question you need to ask is, does that clause cover the breach in question? Okay, now let me show you. I have put together a guideline actually for you, and again let me share my desktop with you to show you how to deal with this kind of a question. All right, where is it? Okay, here, right? So first of all, we have answered this question: is the clause incorporated? And then the next one is, does it cover the breach? And then you need to consider that any ambiguity will be construed against a party attempting to rely on an exemption clause, both the rules, contra proferentum rule, and then other considerations are also listed here in this document that you need to make when you ask this question, that whether it covers the breach in question. So once you have answered those two questions and you have covered the common law area, you need to ask, does UCTA apply? Now for that, you need to ask, is it a business liability? If so, consider the section 1, subsection 3 that defines business liability. Okay, and then you need to ask, is it a clause of the type that is covered by UCTA? And then see section 13 to answer this question, which deals with the meaning of exemption clause. Next, you need to ask if it is a negligence case. If that is the case, then look at section 2 of UCTA that describes negligence liability. And it is stated, for your convenience, I have stated it here in this document as to what it says about negligence. Okay, and after that, you need to ask, is it a consumer contract or a standard term contract? If it is a consumer or a standard term contract, then look at section 3 of UCTA. Okay, so as you see, this section applies as between contracting parties where one of them deals as consumer or on the others written standard terms of business. So you need to consult this section to answer this question. And then you need to see whether the test of reasonableness apply, and if it does apply, is it satisfied? And to see that, you need to consult section 11 of schedule 2 to the UCTA. Section 11 and schedule 2. So section 11 states the reasonable test and gives you the guideline for it. It is here in this document, and here's the schedule 2. It is guidelines for applying the reasonable test that is given to you in section 11. Now, once you have answered that, then you need to ask, is the situation affected by provisions of UTCCR? Okay, and the main provisions are Regulation 5 and Regulation 8 are listed here in this document for you. So I believe you should be fine if you just focus on this area in this topic. that is given here in this document, and you should be fine in your exam. Okay. All right. Thank you very much, and we'll end our lecture on this note. I will send you all of the documents that I showed you in sometime after my lecture today.